we provide for citizens' safety all around the globe, to the extent possible by EASA. And secondly, this is more related to the industry, to ensure that we have a global level playing field for industry. And what is behind this, I will try to explain you a little bit. So the interest of safety is clear. Citizens want to fly when they use aircraft, when they use aviation products in a safe manner. And I think we are convinced that with our approach, with the European approach, with the kind of cooperation between the member states and the responsibilities that EASA has received from the European Commission, we have a good system in place that we can also export and advertise for, and also the outputs of our systems are good. And it helps the industry if they find similar conditions elsewhere in the world. So when we go out and cooperate with other states, I'm not mentioning the US, for example, because they have a very elaborated system as well, as everybody knows. But when we talk to other states, like in Africa and so on, or in Southeast Asia, we are convinced that our system can give them guidance how to work in the future, how to inspect aircraft, how to validate aircraft, and we are quite successful with that. We have certain means how we do this, and I will come to these means in a second. So these are our strategic interests that we are following on behalf of the European Commission. Secondly, coming to the means that we have in place, we have established a global presence. So we are not as spread all over the world like other authorities. However, we have some dedicated offices that help us to implement our strategy. We distinguish basically between three kinds of those offices. On the one hand, we have representation offices. In these representation offices, we have official representatives of EASA that sit together with the delegation of the European Union and is the official focal point for the government, for the authority, for the institutional relationships we have in terms of aviation with that state. Secondly, we have so-called project offices. So we have various projects in place which we use to support other states in developing their aviation oversight system. And in order to support those projects, we sometimes need to have people on site. And for this purpose, we have created so-called project offices. A very big one, for instance, we have in China, and this project office is very helpful for implementing the support activities related to BASA negotiations and stuff like this. I will come to this in a minute. And last but not least, we have the office in Brussels, which is our link with the institutions in Brussels. So it is not a typical representation office or a typical project office, but it helps us to be aligned with the European Commission and the institutions of the European Union. Now, the categories of activities that we perform to increase the footprint of EASA globally and the European system globally are basically two kinds. We have so-called technical cooperation projects. They are normally launched on request of the European Commission, but they are also launched on request of non-European states. So if particular states wants to have a dedicated support to build up a new authority, to revise the authority, to come up with a new regulatory system, they can contact us and we try to support them through a project. Then we have sometimes banks that are financing our projects. So for instance, the African Development Bank is financing a project that helps us to support regional safety oversight organizations in Africa. And last but not least, we have so-called aviation partnership projects. And these are of the most interest, I would say, for the industry because they allow the involvement of industry actively in those projects. With these projects, we can give, for instance, the industry a platform to present themselves to foreign governments, to foreign authorities, foreign industry, and establish a cooperation. I'm just mentioning one field that was quite successful so far in Southeast Asia, but probably also in Latin America in the future. This is helicopter emergency services. So this is a model, if you think of Bangkok, for instance. Bangkok is the city with the highest rate of street traffic accidents. And HEMS systems are not known there. So when we were able to present with European industry support how we work with helicopter emergency services here in Europe, they were quite impressed and they are going to implement something similar, hopefully similar to what we are doing here and based on the experience that we have in Europe. Just as one example. We have other projects of this kind. I will give you a brief overview in a minute. And then on top of this, and I've understood again from the survey that this is also of interest for you, we have bilateral agreements. We call them in general institutional arrangements, institutional agreements. These are formal agreements we have with third countries, either in the form of a bilateral agreement or in the form of a working arrangement, a memorandum of understanding, and you name it. So these kinds of agreements help us also to promote our system and to facilitate, first of all, safe travel of European citizens, but also at the same time give access to European industry to those markets. A bit more on strategy, because I looked at the projects that we currently have in place, and you can basically cluster the strategy, the global strategy that we have, into 4 different kinds, looking at the different continents with which we are working. I'm not mentioning the US here, and I'm not mentioning Russia, because US and Canada, North America, I think we have so well-established relationships. This kind of support, mixed support strategy is not applicable to them, and also for Russia we have a different case. But looking at Latin America, huge continent, huge opportunities, very difficult environment at the same time because of the political constraints. What is our strategy to cooperate with the Latin American countries and especially the regional safety oversight organizations? It is not like in Africa, where we assist states to fulfill the minimum ICAO requirements. It is to develop economic and technical cooperation. So the states are relatively well developed, for instance, in comparison with Africa. Nevertheless, they have problems to implement a system. The harmonization of rules is difficult in Latin America, and we have changing political environments. So what we are doing with strong partners, like with the Brazilian authority, ANAC, we are working together with them through a dedicated project that helps them to set up a system that facilitates the exchange of goods, the acceptance of expertise and pooling of experts and all these kinds of cooperation elements that we have. And this is also covering the Caribbean, by the way, where we have seen that they are suffering a lot from the recent natural disasters, and they also need help in this support. So this is one strategy. Africa, I mentioned it briefly already. This is more the assistance to states. We currently have no project where we involve the industry that actively, because assistance to states, assistance to RSOs, these are really basic requirements that those states have to fulfill, and therefore the kind of support that we are giving is really different. Looking at the neighboring countries, here the strategy is more following the aim of supporting the accession and the integration and the interoperability with the European Union, with the European system, which is clear because they are just next to us. And then last but not least, for the Asia-Pacific environment, this is also the support to strategic cooperation, but on the other hand also, because the mix of countries is wider than, let's say, in Latin America, it is also this element for those states to meet their international obligations towards ICAO. So you see, this gives you a bit of orientation what is driving our activities over the world in terms of technical cooperation and technical support. I have another chart here which just gives a brief overview of the different kinds of projects we have. I have underlined those projects where we involve actively the industry, where we give a platform to the industry. And you see this is in particular Latin America and the Caribbean. And this is in particular the EU Southeast Asia project. Here I mentioned this specific example of the HEMS helicopters. And then we have the EU-China project. And many of you probably know that because you are actively involved in this APP project, there are lots of activities that we are doing together with the Chinese authorities, but also with Chinese industry involvement. And I think we are quite successful. And at the same time, this helps to support the further development of the China BASA that we have recently concluded. Quick overview of the institutional relations we have in place. I think you all know we have this BASA with the US, we have a BASA with Canada, we have a BASA with Brazil. China is new, it was signed in May this year. Sorry. And we have a BASA with Japan in the pipeline, which has been initialed already, and it's going to be signed most probably early in 2020. We have over 120 working arrangements and cooperation agreements in place with more than 30 states. These working arrangements basically serve the purpose of enabling European products to find access to those markets. Typical examples are working arrangements with the Near Eastern states. So it helps them to understand what we are doing. It puts a formal environment under which we are cooperating, and it really helps, and many of those states oblige themselves to accept European products with a minimum involvement, other than in the past where we had a, let's say, unregulated situation oftentimes. And last but not least, I want to mention here the multilateral relations. We have ICAO. We are working a lot with ICAO. We are doing a lot of coordination for the member states, for the European member states with ICAO, have regular exchanges, and we have a person that has been seconded to ICAO. This new person will start as of January 2020. We had previously Rachel Deschler, whom you got to know already during this conference, and the new guy will be Laurent Grousse, also a well-known certification manager. He will start, as I said, in early 2020 at ICAO in Montreal. Very brief overview, because I'm sure that you and my technical colleagues know this far better than I do. For the BASA update in terms of the US, EASA BASA, we have had a BOB meeting at the site of the EASA FAA conference in June. Changes were made to the Annex 2. It has not been finished and put in place yet, but it is being translated currently. The inter-service consultation on the Commission side has been finished, and a MAG Revision 7 was signed in October 2019. The two annexes, 3 and 4, for pilot licensing and flight simulation training devices are still under development, so they are not ready. And what we also are, let's say, more or less regularly doing is updating BOP decisions in terms of fees and charges. Second brief overview is for the EU-Canadian BASA. We also had a committee meeting at the site of the EASA FAA conference in June, and I have to click it, sorry for that. And we agreed on certain principles. So no big changes, but some principles that we would like to focus on going forwards. One of them is that we would like to focus more on improving the cooperation at project level, so at validation project level. And secondly, a first formal annual project review meeting is going to take place in December. This is an outcome of the item that I just mentioned. And then, Markus knows this by heart, I'm sure the list of common TSOs has been updated and a mechanism has been agreed upon how to update this list on a regular basis. What I understood is that was too quick. China is of interest for you. I mentioned already that we have signed the BASA after the initialing in December 2017. We have signed the BASA in 2019. It was signed by Mrs. Bulls, the Transport Commissioner. And we are working on the technical implementation procedures. What is important to know is that the BASA will only be implemented through those technical implementation procedures. As long as they have not been signed, the BASA is not yet in force. So we are working with high pressure on this. We hope that we will be ready to sign them at the next EASA CAAC conference, which will be held in first quarter 2020 in China. And on top of this, we still have a lot of working arrangements with the Chinese. These working arrangements are more or less there to support individual product validation by the Chinese authority. They will certainly become obsolete with the signature of the technical implementation procedures, but currently we are still working under them. And we have, for other projects that have been applied for after the signature of those working arrangements, but before the signature of the BASA and the TIP, we have so-called an interim guidance material in place. There is currently 1 or 2 projects that we are following under this interim guidance material. It's not the optimum solution, but the business cannot stop only because we are waiting for the signature of the technical implementation procedures. Then, on Japan, also here very quickly, we are successfully negotiating with the Japanese. And just for those who have seen it, this is not from the Chinese negotiations or from the Japanese negotiations. I actually had to go to the doctor this morning. That's why I have a scar here. So don't mix this up, please. We have very good discussions with the Japanese authority and with the Ministry of Transport in Japan. And we are very confident that we will have the BASA, but also the technical implementation procedures signed beginning of somewhere 2020. We have also a provision in the bilateral agreement draft that we can use interim procedures. So it's not so like usually with BASAs that we cannot implement the BASA before the technical implementation procedures have been signed with Japan. We will have some possibility and some flexibility to be a bit more adaptive to the situation. Brazil. We had an approval of the amendments of the Annex B for maintenance to the BASA agreement. And then SAFA working arrangements are under discussion and are progressing. We also here expect the signature of this agreement in 2020. In terms of the BASA amendment or the maintenance annex amendment, it is related to specific regulatory requirements, special conditions that we had in place. Also, it includes a wider mandate of the JSCM, the Joint Committee on Maintenance. This is just to complete the picture on the BASA level, what we are doing. Last but not least, not a BASA candidate for the time being, but certainly an important stakeholder for industry, but also for us, is FATA, the authority of the federal, what is it called again? The Russian Federal Air Transport Agency of the Russian Federation. That's the correct name, FATA. So after having made a lot of changes in their system, it was important for us to get again back to normal and have a document in place on which we can rely that clarifies the responsibilities, who's doing what, and so on. So we are actively working on a working arrangement which lays this all down. And let's say the negotiations are progressing well. It has not yet been signed, but it is an important step that we have to take based on a successful assessment of their system in terms of the Article 8.2 under Part 21. So they have successfully passed this, and on this basis we are continuing the elaboration of this working arrangement. Signature is planned in Q1 2020. And actually that's it, basically, from my side. I did not show you this one, but you will get it certainly afterwards. I'm now inviting my colleague to give a presentation on the negotiations with China to complement what I already showed you. Thank you very much.
Good afternoon. Thank you, Frank, for this presentation of EASA international cooperation activities. The second part of our presentation this afternoon will provide you with a more closer focus on the bilateral aviation safety agreement we've just signed with China. So after providing you with a brief overview on the BASA itself, its specificities, its structures, we'll try to go directly into the text and detail the contents of the BASA and the appendix on airworthiness, so that you get a fair understanding of what will be the next state of play, the next rules that will govern the relations between Europe and China in the years to come once the agreement is into force. So first, briefly, Frank introduced the notion a bilateral aviation safety agreement. I said it's a strong institutional link. It's an international agreement between Europe and a given third country. On our side, from what we're going to discuss, it enables the reciprocal acceptance of certificates and findings of compliance issued by the respective competent authorities, amongst others. We'll come back on that particular point. An important point is that it also allows a derogation from the EU law, and it creates rights and obligations for the EU. We'll also say some words about this high institutional level of a BASA. Why do we sign BASA? And I will not spend much time on this because Frank explained to you the purposes of a BASA. Of course, this is about aviation safety when we deal with a bilateral aviation safety agreement. It increases the cooperation between aviation authorities. It enables to put in place a regulatory framework where information is shared. It's very useful to enable each authority to allocate their resource on a risk-based approach and say, because I rely on my counterpart, then I will use my resources to concentrate on the more risk-based activities. This has also an impact also on the resource allocation also of the applicants that know that they can benefit of the mechanism of this BASA. Of course, as a consequence, this supports the aviation industry. It first provides the industry with a sound legal framework under which to work with the counterpart, and it also reduces the unnecessary duplication of certification and validation tasks. Having said that, we may wonder a bit what is special about the EU-China BASA. Well, first, dealing with aviation, dealing with safety, it is a BASA, it's an international agreement with a strong economic safety and diplomatic constraints, which may explain why during all the process of the negotiations, there was a special focus both from the industry and also from the national authorities. It's also very specific because this is a domain, aviation, where when dealing and having an agreement with China, Europe is so far the prevailing industry. It's not like for other agreements when you deal with some industry, other areas where this is China who is the leading authority. We had, in that, starting the negotiation, we came in a position where this is Europe for the time being having the strongest aviation industry, and that have also, of course, an influence on the negotiations. The scope of the BASA in particular, Frank explained amongst the various bilateral partners, the various annexes. So far we've got just one annex that is dealing with airworthiness, which scope will be detailed a bit further. And another specificity is that we had no particular experience with China, at least we ourselves, in terms of Europe authority validating Chinese product. So this is why we built a confidence exercise through a technical roadmap, which entail track 1 and track 2. I'm not going to enter into the details. And finally, the cultural dimensions, of course, when dealing with an international partner. The cultural dimension is also very enriching as well as challenging sometimes. Briefly, this very simple chart is made to answer the question, who won the negotiation? Who won the deal? Did we have at the end a good agreement? In fact, a good agreement is an agreement whereby both parties manage through negotiations to reach a point of equilibrium, a point of balance where both parties will fulfill their main interest and the very important things they brought into the negotiations. And it is only under those conditions, when you manage to find that equilibrium, that you can guarantee that you set the ground for a constructive cooperation, where together the bilateral partner will build and will construct a relation that will continue through the years. And this is really the meaning of that agreement that will, as we will explain, set the rules of the European and Chinese relations over the coming years once the bilateral enters into force. This is a kind of overview of the various elements of a BASA. I don't know whether you're familiar with that. You've certainly already heard about the 3-level document. We talk about BASA. You hear about annexes, you hear about technical implementation procedures. Very briefly and simply, this is just to underline the fact that the top level of the part of the agreement is represented by the agreement and its annexes, and this is something which is dealt with at the highest institutional and political levels. Typically, the signature of the agreement on the 20th of May of this year was signed. Here you've got the signature protocol between our Commissioner, Madame Bulk, and the CAC administrator. So this is something which is negotiated and managed by the Commission with the EASA technical support. And in order to get this conclusion, you need consent of the European Parliament plus a decision of the Council of the European Union to enable that signature. Now, this is for the agreement. Now, an agreement has also annexes. We've seen that we've got only so far one annex dealing with airworthiness with China. On other bilateral agreements, we've got several other annexes. When there is a change in the annex, a new annex that is negotiated, or an amendment to an existing annex, this is something that is dealt with also at quite an high institutional level. This is dealt with by the Joint Committee. In the case of the bilateral with China, that will be dealt by the EU-China Joint Committee of the Parties, created by Article 11.2 of the agreement. And here, typically, it is the European Commission dealing with the highest level of CACs that engage into discussions to approve either changes to the annexes or new annexes. Now, when we come to the technical level, the practical implementation of those political institutional tools that are the agreements, we talk about the technical implementation procedures. This is governed by the COB, the Certification Oversight Board. The COB is a technical coordination body that is created by the agreement, which is accountable to the Joint Committee, and that is taking care of the technical implementation procedures. It's under the joint leadership of both technical agents, the EASA for Europe and the CAC for the Chinese part. The main role and mandate of the COB is to develop, approve, and revise the technical implementation procedures. It's also there to report to the Joint Committee any big difficulty coming from the field that we need a higher level, a higher political level for resolution. It's also here, and it has a mandate to share information on major safety concerns and develop action plans to address them. Let's go now to the annex, the text that was signed. You've got here a very brief overview. We'll go a bit more into detail into the scope and the technical practicalities of its implementation. But the scope, as I said, is dealing so far with the design and the production, all aeronautical products, and there is no temporary limitation. We'll come back to that. It also addresses the production, and the main principle is that there is a mutual acceptance of production systems and export forms under conditions. Various production schemes are covered concerning production, but also concerning certification. For instance, you've got OSD and the operational activities on the Chinese side who are also part of the scope. And you've got many so-called ad hoc cases. These ad hoc cases are meant first to respect and take into consideration the existing situation before the agreement was signed in order to ensure some kind of continuity of business. And this is also meant to make a difference and to treat separately the case where we will act as a validating authority and when the CAC will act as a validating authority. Finally, concerning the relations between the authorities, there are several provisions concerning the cooperation between both parties, but also very important, provisions concerning recurrent mutual assessments. So this is a scheme whereby both parties will have activities of assessing the other party regularly to make sure that the other party is still in a position to fulfill the requirements and the obligations of the agreement. Now, this is the table of contents of the annex. If we have a closer look at the scope, so by the way, there's nothing particular to say. It's quite a classical table of contents. It mirrors a bit what we have on the other annexes, except that this one is only for airworthiness and environmental certification. So the scope covers the reciprocal acceptance of finding of compliance and certificates for airworthiness, environmental protection and continued airworthiness of civil aeronautical products, and also design and production organizations. It's not limited in terms of product category from both sides from the day of entry into force of the annex. This means that the day when the agreement enters into force, the agreement will be applicable on both sides, either to CAC and to EASA, and it will encompass all the range of the aeronautical products. There are very few exclusions. For instance, used or rebuilt engines, propellers, parts, and appliances are not within the scope of the annex. However, the used aircraft, used complete aircraft, are within the scope of the annex. And the Chinese PMAs are excluded from the scope of that annex. Implementation. So when I propose that we focus a bit more on the design, So when we deal and we talk about the validation of the design from each party, we have adopted, or both parties have adopted, a kind of risk-based approach, and the validation will be conducted under two main paths. The first one being the automatic acceptance. So in that case, when we deal with an automatic acceptance, the prevailing principles are the following. The VA, the validating authorities, in that case, recognize and accept the CA, the certificating authorities, certificates, without any technical investigation or validation exercise. When we deal with automatic acceptance, the certificate of one party is recognized by the other party as equivalent to its own certificate, as it had been issued in accordance with its legislation and procedures. So that means that the VA practically does not issue its own corresponding certificate. There is no application and no technical investigation. Or, if we cannot fall into that category, there is a validation. The validation may be either technical validation, putting into practice the level of involvement principles that we will define a bit later, or a validation through an administrative process, in some cases, as detailed in the tip and the annex. Concerning the level of involvement of the validating authority, the process and the principles of the process are detailed in the technical implementation procedures, but they're based on a maximum extent practical on the technical evaluation test, inspection, etc., which are done by the other technical agent. So you rely on the other agent and you take as much credit as practical on the job that has been already provided. Of course, in the tip and in the annex, you will find special procedures and scrutiny whenever, because we are advocating a risk-based approach, whenever it is the first time that you're confronting with the validation of a given product, then there are special provisions and special procedures that will apply. This is normal, because if you base your approach on the confidence you put on the other system, the less knowledge, experience, exposure you have with that system, the more you should be involved. And the last point is the effective implementation of the technical implementation procedures and the principle of a level of involvement that will be measured and controlled by the COB. That's one also of the very important missions of the COB, is to make sure through the collection of metrics that are defined in the tip that both agents really play the game and apply correctly the tip, and there will be a mechanism of collection of metrics to review regularly and monitor that the tip principles are indeed followed and adhered to. Some more considerations concerning the level of involvement. As we say, this is a risk-based approach, and the level of involvement of the VM must be mainly determined by, as we said, the experience and records of the competent authority of the other party as certificating authority. Well, what it means to say is that the more you're dealing with an authority that has a huge experience on a given range of products, that has issued a lot of certificates, is a state of design for a lot of products, and the more you're inclined to have confidence into that authority and say, okay, I'm dealing with an authority having a huge experience in that, I will give credit to that experience. The second point is that the experience already gained by the VA during previous validation exercise with a competent authority of the other party must be recognized. It's not all to face an authority with a lot of experience. You need also to ensure that your experience as a VA with that authority is sufficiently wide, is sufficiently positive, so that you can build on the trust you're putting on the other system. So, of course, the more you've been exposed in the past into that, with that validating authority, the more you should trust it. Of course, provided that experience was positive. Then comes the nature of the validity design, the performance and experience of the applicant with the validating authority. Of course, this is not the same approach when you deal with an applicant that presents for validation a very simple light airplane and has always been performing extremely well, than when you deal with an applicant that is coming to you for the first time and that is presenting a brand new concept of a very complex large airplane. And finally, the level of involvement will take into account the outcome of the initial and continued qualification requirements assessment that we have introduced, is to say the continuous requirement that both parties will exercise to make sure that both systems do enable each party to comply with the agreement. So that was it for the frame, for the the explanation of the BASA itself. I propose now to you to go really down to the text. This is merely an extract of the annex, and we will investigate both sides. First, EU to China. So when China and the CAC is the validating authority of the European products, and then afterwards we'll see which are the validation paths that are used by Europe, by EASA, when validating the Chinese products. So the first case is the type certificate. Whenever you've got a TC which has been issued by European Union competent authority, then those TCs will be validated by CAC. They will be validated in accordance with the level of involvement principles, reason why we spent some time previously to give an understanding of which are those principles and how that does work. However, in that case, there will be some data that will be automatically accepted as specified in the TIP, and we're still in discussions with our Chinese counterpart to really find the good conditions that will govern this disposition of the annex. However, the annex recognizes that some data should be automatically accepted when performing this TC investigation. If we now consider the supplemental type certificate and the significant major changes approved by the EU competent authority, they will be validated. So the STCs will be validated, and the significant major changes of TC holders, of EU TC holders, will be validated by CAC. The significant STCs, as well as the significant major changes, will be validated in accordance with the level of involvement principles that we have explained previously. However, some significant supplemental type certificates and some significant major changes, as detailed in the technical implementation procedures, will be validated under a so-called streamlined validation process. So the streamlined validation process is an in-between between a purely administrative process and a full technical investigation. This is a process where you send an application data package, you perform a technical familiarization, but it stops here. The validating authority does not have an involvement in the checking and in the showing of compliance activities. So it's a kind of light touch technical validation. So there will be some significant STC, EU STCs, and some significant major changes that will be submitted to that particular frame. Excuse me. Now, concerning the non-significant supplemental type certificates, they will be validated through an administrative process only, meaning that you submit an application with a given data package. We'll see afterwards that there is a time-bound process whereby the other party will approve this certificate without any technical involvement into the showing of compliance activities. The non-significant major changes, as well as the major repairs approved by the EU competent authority, will be automatically accepted by CAC. So that means to say that CAC recognizes and accepts the EASA certificates without any technical investigation or validation exercise. And the EASA approval, so the non-significant major change, for instance, is recognized by CAC as equivalent to its own certificate issued in accordance with CAC rules. There is no application, and there will be, as a consequence, no issuance of CAC of its own certificate. This applies also to the minor changes and the repairs approved by EU. Technical standard order approval authorizations issued by the EU competent authority, they will be submitted to a validation, but an administrative process validation, meaning that there will be an application to CAC, a data package, review of the data package, and then an issuance of the corresponding certificate within the Chinese system. So this was for the EU to China flow. Now let's have a look at the China to EU. And this is why we spent some time explaining the main principles of the level of involvement. The type certificate issued by CAC will be validated by EASA in accordance with the level of involvement principles that we've detailed. This will apply also to the supplemental type certificate and the major changes, as well as the major repairs approved by CAC. So they will apply to EASA, and there will be a validation by EASA in accordance with the level of involvement principles. Concerning the technical standard order approvals issued by CAC, the CTSOA, they will be validated by EASA in accordance with the LOI principles. However, similarly to the provision introduced for some significant EU STCs, we agreed that there would be some technical standard order approvals, as detailed in the tip, for which we, EASA, would only perform the streamlined validation process. So that means that we, for some TSO, Chinese TSO applying for ETSOA validation, we would limit our investigation into the review of the application package, a technical familiarization, and then we would issue the corresponding European certificate. The minor changes and repairs approved by CFC will be automatically accepted by EASA. This is mirroring the risk-based approach we were discussing previously. And this is a provision that you will find throughout all the other BASAs. Typically, the minor changes and repairs are automatically accepted. Few words concerning a bit more of details concerning the administrative process. So once more, this is no technical investigation. There is just a data package that is sent to the validating authority. It applies to the EU TSOA and to the non-significant STCs submitted to China validation. So they will be submitted only, those two categories will be submitted to the administrative validation process. As soon as the validating authority receives the complete application package, as detailed in the tip, the process is time-bound. That means that the validating authority has a maximum of 3 to 5 weeks, depending on the complexity of the product, to issue the certificate approval. This is something that is echoing what has been introduced in the EASA FAT provision 6 for the basic STCs, where both parties take the commitment of issuing their validated approvals in a time-bound frame. So this is for the administrative process. Concerning the classification, what is minor, what is major, what is significant, what is not significant, this is within the annex. The classification is made by the certificating authority. So the validating authority accepts this classification. By the way, the criteria and the definitions have been inserted within the annex. They are similar to the EU Part 21 definitions. And so those criteria have to be interpreted in accordance with the applicable rules and procedures of the certificating authority. This is to ensure that there is an aligned understanding of what is minor, major, and significant, non-significant. Finally, the next steps, but I will go rapidly because Frank already touched base on that. So the signature happened on the 20th of May. After there was a Council decision on the EU side, which was published on the 15th of June. You will find, if you have not yet opened that document in the slides, an hyperlink to the very interesting explanatory memorandum that is published by the European Commission, explaining the reasons for such an agreement. It's quite an interesting reading. We will need, before the agreement enters into force, to have a ratification and an exchange of diplomatic notes. That means that we need a consent of the European Parliament and a concluding decision of the Council of the European Union before this exchange of diplomatic note can take place. After that, the agreement itself plans for an entry into force on the first day of the second month following this exchange of diplomatic notes. It's only after that delay, that time frame, that the agreement will be into force. And of course, this agreement being into force, the joint committee and the certification Oversight Board will be created, and they will be able to adopt the technical implementation procedures. So I would like maybe to preempt one of the questions. When is it going to happen? You understand that ratification, consent of the European Parliament, decision of the Council of the EU are very high-level political processes that take time, which are absolutely not under the control of the agency. And what we are ready to do, what we committed to, is to be ready and have a mature tip text that should be ready to enter into force as soon as the agreement is done. So we will not be in a position where we are late and do not have a tip ready for implementation once the agreement is in place. I thank you very much for your attention, and I would be pleased to answer your questions with Frank.
Thanks, Charles. Thanks, Frank. Well, we got a few questions, and I think we can display them right away, and maybe you can, one of the two of you, answer directly to them, and just indicate which question that we can take it off the list.
So I think we start from the top. The criteria that are used to determine if a bilateral is beneficial. So I have to say that the decision whether a bilateral is signed or not is not only a technical one. It is also a political one. So the decision on the way forwards with regards to a bilateral agreement is made by the European Parliament. The Parliament has to give a mandate for this, and then it is followed up by the European Commission. EASA is supporting this, and EASA is giving its opinions, and EASA is developing procedures, processes, etc. But the decision is not in our hands. I can confirm that technical matters are definitely decisive, because, for instance, continued airworthiness is an issue. If you have no bilateral in place, then this is more difficult than with a bilateral in place, in many cases. On the other hand, the work that is linked to a bilateral is not should not be underestimated. It's a process that normally takes several years, and it goes through all kinds of institutions on both the side of the bilateral partner and also on the side of the European institutions in Brussels. So that's why it's always a decision: is it worth taking the effort? Is it politically worth taking the effort? Is it time to do this? So all these considerations need to be taken into account. There is no black and white decision. Next one. BASA and TIP with well-established CAAs like Singapore, Hong Kong, or Australia. Now comes the point in terms of political considerations. I think there are definitely no obstacles. On the other hand, it's a matter of size and magnitude, whether we do this or not. We are currently developing, besides the fact that we have working arrangements with all of these states, but we are currently developing a dedicated working arrangement with Singapore, for instance, which allows the facilitated acceptance of findings related to maintenance organizations. This is already going into the direction of accepting each other's inspections and oversight systems. But it's not a bilateral, because we have to walk a thin line. It's not in both directions. Our possibilities are limited. We cannot, under a working arrangement, accept something that bypasses our Part 21, for instance, whereas other states can do it. So also the need for a BASA is really dependent on the amount of export we can expect from those states. Yeah. So I cannot confirm at this stage that we are developing or going for a development of a BASA with Singapore, Hong Kong, or Australia, but you never know what happens in the future. The decision is with the European Commission. CTSO.
Okay. I will take the next one. CSE is currently issuing CTSOs. The question, yes, they do. Do CTSO, are they acceptable in the EU? No. They will become, after the entry into force of the agreement, that there will be a validation scheme applied to those CTSOs, and I explained some of them will be streamlined, validated by us, but so far there is no possibility so far for a Chinese CTSOA holder, being a Chinese entity, to apply for validation of the CTSOA. Second one, does CSE currently accept applications for the validation of EASA STCs under the interim procedures? You mentioned that, Frank. Yes. Up to recently, as you may have known, there were working arrangements per company, per STC signed between the EASA and CSE for a given applicant. And if you were unlucky, if your STC was not covered by one of these working arrangements, you had either in the old times to enter into the arrangement and have a new working arrangement, or, and that was the situation up to recently, there was no possibility because CSE, in the frame of our discussions, decided to freeze the existing arrangements. So we've had a period where it was not possible to proceed anymore. Since the signature of the bilateral agreement, there is an interim guidance procedure which has been put into place, and that gives a kind of a legal framework on which to work, and that enables you to apply for validation of your STC to CSE. Do not hesitate to contact us. We will provide you with the procedure to follow for that. What is the expected time scale to complete a project with a CAC under the interim procedures? Well, those interim procedures, they are meant to be as practical as feasible. Of course, you understand with what we've presented that For some EU certificates, it will go faster once the BASA is into place. Now, this is really a very broad and legal framework to enable you to make an application to CAC. Those interim procedures promote some level of involvement principles, but they do not have the value of an international agreement. So it's a very vague commitment, and so it's very difficult to give an answer, except that depends on the complexity, the quality of your showing of compliance with the CAC requirements. But here again, do not hesitate to contact us. We're here to support you when you are engaged in such kind of validation with CAC. So non-significant STCs are also automatically accepted. Not exactly, Johannes. The non-significant, well, EU non-significant STCs, they will be submitted to an administrative process validation. So you apply, you send an application, there is a data package, and there is between 3 to 5 weeks in accordance with the complexity of your STC to get the CAC validation. But they will not be automatically accepted. You take this one? Okay.
So I'm not aware of any case where we had a BASA and that was then given up or cancelled later on, entry statement. Besides that, of course, we have oversight boards in place. We have the bilateral oversight boards. We have the technical oversight boards that are responsible for the different technical domains that are covered by a bilateral. And so if something doesn't work, if something is not efficient, then this is brought up in these oversight boards, and we try to be more efficient in the future. Typical example is with the FAA. This has been a process that had been going on for years with the individual member states. It was then continued with the EASA, and whenever it comes to efficiency gains, there were discussions between the parties, and we try to find common solutions. That's more the way how we do this. Of course, the Commission has also its view. This is more on the political side. But there is no formal process to evaluate through statistics, at least on our side, the effectivity or the efficiency of a BASA. Efficiency, yes, to a certain extent. Maybe you have heard about the activities that we had with the FAA in terms of the fees and charges regulation, because this forced both parties to become more efficient in the validation of each other's products and parts and appliances. We even stipulate in the fees and charges decision that is related to this, numbers of working hours that can be used and so on. So there are mechanisms in place, but it depends on the BASA, and it depends very much on the bodies that we have in place, like the bilateral oversight board and the technical oversight boards. Next one on the, sorry, I was too quick, the existing VTCs. I think the certificates that have been validated previously, once the BASA enters into force, they are grandfathered. So there is no reason to assume that these certificates will become invalid.
Try to get the next one. Are there proper training of certifying staff for DOP NMO at CAC considered by EASA? I'm not sure I get exactly the point here. Are we considering a training that we would deliver to CAC staff? Or is more the question about the trainings that will, that was a point. We've got, well, maybe you want to say a few words about the APP?
Yes, okay. So I'm not aware that we have any dedicated training like this under the bilateral, but we have in the APP, in the Aviation Partnership Agreement, we have a provision for training. And for instance, the Chinese CAA colleagues are visiting EASA oftentimes, and we give often trainings to those colleagues in terms of the European rules for maintenance, European design rules, on all kinds of matters, from drones up to airport certification and so on. So we have mechanisms in place to support the training on the side of the Chinese partners.
Do we recommend to wait for application for the sign tip? Well, the answer would be, it's up to you to decide. We presented you with the conditions that will prevail once the tip comes into force, and you've got to balance both your interest of having your certificate already and quickly validated. So you may have identified that playing under the new rules of the bilateral agreement, it may be easier for you. Now, the agreement is not yet into force, so you've got to balance the risk of waiting for the entry into force of the bilateral agreement and engaging now with the CAC. It really depends. There's no overall decisions on that. I think we've tried to explain to you which were the ways that in the future will be easier for an EU applicant, but it really all depends on which are your immediate concerns and what you want to achieve right now.
Charles, I think on this one, as far as I understood, we will have a list of standards between China and the EU. And the JTSOs quite likely will not be part of that list, so that's why I assume that the old approvals will not automatically be covered.
Yeah.
Or?
Yeah, maybe to complement, if we're talking about CAC approving and accepting the ETSOs, the agreement just only covers the ETSOs. So, and there will be, for this can, there will be no list in that case. By definition, European TSOs, that is issued by us, is submitted to an administrative validation by CAC, time-bound process, as we said, and then there is the validation by CAC.
Okay, thanks a lot for the information and for the questions. Then we come... And then we have Michael Gerhardt again. He's so popular, I think you will win a prize, Michael. Again, triggered by some comments and proposals from you when we selected topics for the agenda, Part 26, CS26, and Michael, I think you will be supported by Xavier and Yuri on this presentation.
Yes. Thank you very much, Markus. So indeed, a number of you had interest to get an update of Part 26. Quite up to date because there were some changes this year. So we decided to take this as part of the program, and we can see for the next years whether it makes sense to continue this regular update on Part 26 topics. Maybe to start with and to introduce the topic, just to refresh your memory of what are we talking about actually, what is Part 26. So when we are in the CS25 world, when we introduce new CS25 certification specifications or amend existing ones, those are applicable for new applications that we receive, for new designs for the future, or for new STCs or major changes in the scope of the Change Product Rule 21A 101. So these design improvements, these improvements of the specifications have a consequence for future designs. But there are also some important design improvements that we want to also apply retrospectively, where there is a huge safety benefit to apply them retrospectively. And the tool actually for that we have, or to be more precise, that the Commission has, is Part 26. I say Commission because of the retrospective nature of these measures. It can only be adopted in a law, in a legislation. So Part 26 actually is a regulation different from CS25 that is adopted by the agency. So these retrospective measures, we do have two tools. We can either, with a relatively limited impact, all of these retrospective activities by nature have an impact on your business. The limited impact is that we require production cut-in. We already have an approved design, an approved TC, but as of a certain moment in the future, normally 1-2 years after the adoption of the Part 26 rule, you have to stop producing in accordance with the approved design, and for that bit have to also comply with the Part 26 requirement. Or, if it's even more important that there's an immediate change, then we can also mandate a retrofit into the existing fleet. Also aircraft that have already been produced, which are flying, can be required to be retrofitted. This, of course, has a much higher impact. So you see that the big work in the Part 26 world is to do a proper regulatory impact assessment. Very often the regulatory text is only 5-6 lines, but the majority of the work is on assessing the impact for these retrospective measures and finding the right tool to achieve the safety improvement. Together with my colleagues Xavier Vergès and Yuri O'Rourke, I want to introduce you where we are today with Part 26, what has recently changed, and what we are actually working on for the future. So, beginning this year, there has for the very first time been an amendment to the Part 26 regulation. So in terms of number, the Part 26 regulation is a regulation from 2015 with the number 640, and this regulation at that point in time actually only transposed what was already existing in the JEA world in JAR 26. Now, beginning of this year, with the regulation 2019-133, which was adopted in January, for the first time we introduce new additional airworthiness requirements, new Part 26 requirements for operations. And this regulation introduces three topics: replacement of halon, seat crash worthiness, and thermal acoustic insulation material. To show you a little bit, I don't want to go into very much detail. I don't want to fully read out these slides, but just to give you an idea of what we have on these three topics, and especially what you see here highlighted in red, the compliance dates. So looking at halon replacement, we decided for a production cutoff, so the first tool. There are two aspects to it. For fire extinguisher, which are placed in the lavatory waste receptacles, for any aircraft that goes out of the production line and receives a first certificate of airworthiness after February 2020 has to use other agents than halon. And for portable fire extinguisher, the measure is already in place. So the regulation was adopted beginning of the year, and since 19th of May this year, any aircraft coming out of the production line cannot have any handheld fire extinguisher using halon any longer. So there was a very short transition period to that. My colleague Yuri can give you some additional information on recently published guidance. So Yuri, if I can give you the floor for a minute.
Yeah, we have published last week what we call the halon guide. So it's a document developed conjointly by EASA and the European Commission to the attention of the industry applicants to help them to interpret the ozone regulation and to understand, depending on their product, on the application date, when or if the halon regulation applies to them. So we hope that it will be helpful for you, and we invite you to have a look at this document. It is published on our different social medias. And it was also a kind of gift to compensate that you cannot attend to the Christmas market this year.
Thank you, Yuri. Good tip. On seat crash worthiness, operators of large aeroplanes used in commercial air transport, also here we have a production cut-in for aircrafts first issued with the C of A after 18th of February 2021, shall ensure that the aeroplane seats in the cabin are equipped with 16G seats. And on thermal acoustic insulation material, you find a production cut-in, but also a retrofit requirement. So it's the only retrofit requirement in this package. So the retrofit bit is the first indent, sub-indent that you will see on the slide on the right-hand side. So when, for existing already flying aircrafts today, after 18th of February 2021, the insulation material is replaced, it has to comply, the new insulation material has to comply with the new standard. And then a production cut-in any aircraft coming out of the production line and issued with a C of A, first C of A, after the same date, 2021, also has to comply if it has a passenger capacity of more than 20 or more. And this is what you see on the slide, almost the full regulatory text in Part 21. It's 90% the wording that you see in the regulation. So you see it's a very short regulatory drafting, but when you have a look, especially in the opinion and the NPAs, the impact assessment is very heavy until we decide that we require such a retrospective measure. So this was the first ever amendment of Part 26. We have some ongoing rulemaking activities where we also addressed and assessed whether it's necessary to amend Part 26 with regard to further topics. And there are two opinions currently pending with the European Commission for adoption for further amendment of Part 26. The first topic is quite an old one, also relating to the title of the topic. It's about aging aircraft structure. We issued the opinion in 2016. And then there is a recent opinion from a couple of weeks ago, which addresses two topics. It's the reduction of runway excursion and the conversion of Class D cargo compartments. The Commission has started to work on these topics. They will be dealt with in a single package. So what we can expect is to see the next amendment of Part 26 being adopted by the Commission, probably out of these three topics. I would like to give you, together with my colleague Xavier, or actually I will ask my colleague Xavier Vergès, to give you a brief insight into each of these three topics so that you have an idea what we already proposed to the Commission and what may come your way next. So Xavier, please.
Slide. So good afternoon, everybody. Yes, so regarding the first topic, for which the opinion was published in October 2016, so obviously it has been delayed, not for technical concerns, but because of a need to absorb a certain backlog at the Commission level and to make prioritization, but now it is being worked on actively. The objective is here to better mitigate the phenomena of aging aircraft structure as applicable to existing large aeroplanes and future large aeroplanes. And the particular risk that we are focusing on are the fatigue of the basic type design, the widespread fatigue damage, the corrosion, the effects of the corrosion, the damaging effects, and the fatigue of changes and repairs applied to the aeroplane. The proposal affects both the design approval holders and also the applicants for TC, STC, and repair or changes to those products. And it also affects, obviously, the operators and the owners, because the ultimate goal is that the maintenance program are amended to better control those risks and to implement corrective actions when necessary. So the proposed regulation is relatively complex, and therefore it considers different time periods in terms of compliance that are proportionate to the efforts which is needed to comply with those requirements. The second topic, which is part of the last opinion that we've just issued in October, is the reduction of runway excursions. So runway excursions is one of the two top safety items that is regularly identified in our annual safety review. So it's number 2 in the previous one, and the one before it was number 1. Design solution exists to help the pilots of large airplanes to identify when the aircraft is at risk of not being able to stop in the available runway distance, either during approach or even after touchdown. And so we think that we should have those systems, those means available for new design, of course. So we are preparing a CS25 amendment soon about that, but also to aircraft that are produced from a certain date. So based on our impact assessments, we have proposed this way, not a complete retrofit, but a production cut-in. And this will allow to mitigate mainly, to prevent mainly longitudinal runway excursions, but also in some cases lateral excursions, because we often see some lateral excursions combined with longitudinal runway excursions. And the last one aims at mitigating the risk of uncontrolled fire in cargo or baggage compartments. So more specifically, the risk that exists with Class D compartments, which is a category of compartment that is not allowed anymore on new designs since some years already, but that are still flying today, at least in EASA member states. And so we think that the risk posed by those compartments, especially having in mind recent elements that increase this risk, like the widespread transportation of lithium batteries. So we think that those compartments should be converted, so to comply either with the specifications of Class C or the ones from Class E compartments in terms of detection of fire and means to extinguish the fire. The proposal includes requirements for full retrofit, of course, and we have proposed 3 years after the entry into force of the regulation. So that's all from my part. Michael will now give you an overview of what will come next, potentially, as included in some rulemaking projects.
Thank you, Xavier. So when you study the EPAS, and especially the rulemaking program in the EPAS, or follow the terms of reference of a number of CS27, CS29, CS25 rulemaking tasks, you will also see that very often at the beginning we put in there that we also want to assess whether it's suitable to also address the design improvement retrospectively. So in addition to the 25 improvements, we'll very often have in the scope of the project also the assessment of whether it's necessary to also amend Part 26. And in the current program, we have this foreseen for 6 ongoing rulemaking tasks. In terms of timelines, we can package them in these 2 packages, where in the first package, according to the current planning, we may come up with an opinion in 2021. And for the second package, the timeline for the opinion is beyond 2022 for an opinion. That does mean an adoption maybe a year, 1.5 years later. For on-ground wing contamination, we have almost completed the impact assessment, and there it looks like that we will not propose a Part 26 change. But you will see the NPA, including the impact assessment, at the beginning of next year. For helicopter ditching, we are still in the middle of the regulatory impact assessment. There we plan the NPA, the Notice of Proposed Amendment, towards mid next year. And for tire pressure monitoring system, we have concluded the impact assessment and we are preparing the NPA, and there you will find a proposal for a small amendment in relation to the ICAs for tire pressure monitoring systems. So these three topics, the first, let's say 118 and 586, probably with no or very minimal impact on Part 26. Helicopter ditching we have to see, but I expect that this will result in some Part 26 changes. And the three other rulemaking tasks on rotorcraft survivability, rotorcraft oil monitoring, and rotorcraft bird strike have just commented. So we are in a very early process. We have started to collect the data, and we will start doing the proper impact assessment in the coming months. So it's difficult at that stage, no, it's impossible at this stage to tell you whether this will lead into a Part 26 amendment, but for those tasks, we are considering this as an option subject to the regulatory impact assessment that we are conducting. So, time for Slido.
Yes, and we got a few questions, and you have them in front of you.
So what is the agency's expectancy from a DOA holder during certification activities in terms of referring to CS26? Yes, so we do have a certification specification in relation to Part 26, which gives the means of compliance with Part 26. Either you find specific means of compliance or a reference into the existing certification specifications for new designs, so in CS25, CS27 or 29. So these certification specifications should guide you to comply with the Part 26 requirements. Between the operator and the CAMO managing the aircraft and the DOA modifying the same aircraft, who is responsible for ensuring compliance with Part 26, CS26, it's predominantly the operator. And you will see it in Part 26 itself. We will always identify who is responsible for what. So if we would go back to the slides on halon, seat crash worthiness, we try to put there in the first line who is responsible. Operators of large airplanes, operators of large airplanes used in commercial air transport. So the primary responsibility is always with the operator. We do have, and we will have some requirements where we will address the TC holder. In the aging aircraft proposal, for example, we also address certain requirements on the TC holder. But you will see that always directly from the Part 26 text. For future, will future TCDS amendments reflect the new Part 26 requirements? That questions I have to pass on. Do we have a chief PCM in the room? Any one of my colleagues know whether this will be reflected in the TCDS? In case this will lead to a change approval?
I think the answer is no. It will not be reflected.
Will not be? Okay. But then we will reply to that specifically after the workshop. Okay. Aging aircraft structures, Leo, be prepared. Is the EASA rule in line with the FAA requirement? Is the FAA stage process static threshold interval recognized and accepted? 99% yes. So the expert for the rulemaking task is in the room. So yes. So actually with this rulemaking task we catch up with what the FAA already has done a couple of years ago. Will the aging aircraft change under consideration be similar to the CFR 26 subpart C and E? So yes. Halon extinguisher, how is first CFA defined, e.g. for an aircraft operated outside the EASA until now is phased into the EASA environment and gets its first CFA? So it's probably not part of the Halon guidance because it's a generic question, right?
No, it's not part of the HALO guidance, but in this rulemaking task, we have a line, so to say, with ICAO Annex 6, where it's the same requirement, and they are also talking about the first individual airworthiness certificate. And in our case, also, the spirit is really the first one, no matter where the aircraft was registered.
Okay, thanks. Which is the status of approved ETSO for portable fire extinguisher? We haven't worked on the ETSO. I look at the same person again. ETSO for fire extinguisher. There was no change in the past, 2 amendments, if I remember correctly. No. Maybe Federico, can you clarify what you had in mind with that? Do you have a microphone?
Was it the one regarding the ATSO, right?
Yes.
Just to know if there are ATSO approved alloy replacement portable fire extinguisher.
We do have ETSO on fire extinguisher, yes.
But no, the ATSO, yes, I know. But if you have approved,
if you issued authorizations,
yes.
Well, you should be able to find that on our website because we publish all ETSO authorizations on our website. And if you go there, you will find either by ETSO standard, by company, the approval and the reference. So the data is available on our website. Marco? For the microphone.
There is no ETSO approved for the time being, but we have already application for Halon replacement handheld fire extinguisher, yes.
So is it possible to request a derogation to national authority about the use of portable fire extinguisher in relation to its operational use? So Yuri, I think this is described in the Halon guidance.
Yeah, in the Halon guide, we give the first steps on how to apply to derogation, but regarding the ozone regulation. So here, I'm not sure if we are talking about the ozone regulation or Part 26.
Part 26, Federico again. Yes, yeah.
Then
Part
if it's in relation with Part 26, so it's the flexibility provisions of the basic regulation which applies. Yeah. And the operator can request a derogation to its competent authority, indeed.
Yes. So what used to be Article 14, which is now Article 71.
71, yeah.
And then, are there any changes anticipated to Class F cargo compartments? To my knowledge, no. Yuri, did we discuss that as part of the rulemaking task? No. So no consideration ongoing.
Okay, thanks a lot, Michael, Xavier, and Yuri for the update on CS26. And now we have the update, as requested by a lot of you, on SEPIAC and the IT projects at EASA. I don't know, Eric Sivell, head of IT, and Andrea Castoldi will guide you through the updates and the plans for EASA in terms of Coral and digitization.
Okay, we won't make you suffer too much. We know we're last, so. My name's Eric Savelle. Andrea Castoldi. So what my part is to do is how EASA is now going to follow the world that's being digitized. Today, EASA's IT systems are more to the left. We have a lot of systems that date back to that time, and a lot of you are on the right. And what we have to do is move EASA from the left to the right, so from the 20th century into the 21st century. It's easier said than done. What do we need to do? First of all, EASA has to start managing data. We do a lot of managing of documents, a lot of managing of papers, a lot of managing of wet signatures, certificates, things like that. We have to start seriously managing data. Secondly, we have to harmonize our standardization journeys, our certification journeys in such a way that we can digitize them in an easier fashion. We issue a lot when we oversee a lot of organizations like DOA, POA, and others, and a lot of these journeys have slight differences. Sometimes are based on regulation, but often are just based on habits. So we have to do a lot of work to harmonize our certification journeys. We also have to break the silos. Like every organization, we have silos. We have people who work in DOA, people who work in POA, people who work in ops, and et cetera, et cetera. So we have to start breaking the silos so that the data we've created can move from silo to silo. Then we have to improve our agility. A lot of the things we do today are quite slow. And sometimes we're very slow in upgrading our systems. So we have to learn, like many of you have done before us, to be more agile and quicker in the way we adapt to what's happening. And also, because we're digitizing, we have to review some of the job profiles we have in EASA. The way we did business, let's say 10 years ago, won't be the way we do business in 10 years once everything has become digitized. So all this is what's ahead of us. It isn't just having brand new IT systems in place. It's a much wider effort that's being done, and that effort started 2 years ago under the auspices of Patrick Key. And in the last 2 years, we've had a year of preparation, and now we're actually beginning to purchase IT systems to review our processes, and soon you will see the first results. The first system we bought is the new digital identification and authentication system, and you will see that enter into force in January or February. So slowly you will start seeing on our website, on the way you relate to us, new systems appearing. What it's not about is having PDFs and scanned certificates. What it's not about is keeping the old processes alive without any change. What it's not about is running one application for each task we do. What all this is not about is using the old system and waterfall, and when you ask for something, we spend 3 years working on a new system. And what it's not about is staying with paper and manual processes. Many of you now use digital and use data in your daily work. We have to be able to do the same thing. So what's the plan? First of all, we have to work on our information management. We have to change the way we used to work and go from document management to information and data management. That's underway. We now have a team of people who are working very hard to transform what we used to do into a more digital and data management approach. The next step we have to do is connect to you digitally. That means secure our accesses. Make sure that when you connect to us, you have the same level of security as the level of security that you would expect. What we also need to do is have common interface, the same look and feel, so that when you work with us, it's the same, and you can sometimes also work with us using your own systems. So to have machine-to-machine links, so you don't have to change or to adapt to our systems. And finally, we have to start having data analytics so we can share the data and do analytics together and be able to improve our efficiency together and to improve our knowledge of the system together. The third step will be what we call external digitization, and that will be the use of machine-to-machine, artificial intelligence, and to cut a long story short, to offer new products. When you become more digitized and when you start having digital products, let's say, for example, predictive maintenance, we will need to be able to have the digital systems that accompany that move to predictive maintenance. So it's also all about you. We've already developed a certain number of digital and agile flows inside EASA. There's one on resource management and how we manage our resources. That's already started internally. There's another one which you'll see coming out with the new fees and charges in January, and that is the one about data exchange and the contact you have with us. And the third flow, which will start as of January, is the digital processes. So in the coming year, the people who oversee you will have a digital tool to help them do their oversight. It will no longer be paper and PDFs and things like that. To be able to do that, we have to stay in touch with you. There has to be interactions. We have to understand what your needs are. We have to have constant interactions with you. When we simplify the process, it also has to be a simplification on your side. We can't just simplify the processes on our side and digitize the processes on our side. You also have to be involved in the digitizing of our processes and their simplification. Therefore, we have to be proactive. And we'll soon be organizing meetings next year with the people who use our systems or who interact with us to see what sort of digital change you expect from us. Finally, we will also need to have trainings inside EASA to better understand not only our digital systems, but maybe also, and probably, to understand your digital systems and to better understand how you have digitized, for those of you that have already made the crossover to a more digital world. And the final thing we have to do is we have to work on making the work people do more fun and more interesting. If digitization means making things more complex, more difficult, more boring, people will resist, will not move towards a digital change. So we have to work a lot on what we call user experience and make that easier for people to use. So we need you, and we will have interactions with you on how we build the systems. You're our stakeholders, and you will be our interface. So we need to be able to work with the larger counterparts, but also the smaller counterparts, the medium-sized enterprises, to be able to build the systems that function for you. We can't just build the systems for one or two companies. Digital change is about everybody. When you're changing, and we have to accompany that change, and we can't guess what you're doing. So we're going to have to interact to be able to build the systems you need. That's why your systems will make the difference, and we've named the focal point, who will be the manager of what we call the transformation office inside EASA, who will work on transforming EASA and making us a more digital agency. And that's Christopher Holgate-Romanov. Some of you already know him because he used to interact with you in the past. And that's about digital transformation.
Shall we run the slide on now or all at the end? Do I have to press something myself? Or?
Can you go back to the presentation, please?
Okay, so welcome everybody. Since this is the last presentation of the day, I will promise it will be light.
There's one more.
Okay. Okay. So, as you have understood from the presentation from Eric, there are big changes in all the EASA IT environment and all the way to work. And SEPIAC, as you have probably understood, is a piece of that. And then the focus of my presentation is really how is SEPIAC integrated with this one, and how is SEPIAC doing in all this. So the first thing to say is that SEPIAC is doing quite well. In the last couple of years, we have seen the number of projects that are being managed and the number of companies using it ramping up quite steadily. We could also see that in May this year, we had a big ramp up of organization using it due to the fact that we moved the full ETSO projects inside SEPIAC for the new application. As you can see, that this is quite stable, the way that it is used by us, by industry, and by our NAA partners. has been quite clear from the presentation of Eric that things are changing, and also SEPIAC will flow inside the Coral and inside, let's say, a bigger environment and framework. But what happens in the meanwhile? In the meanwhile, we are working to improve day by day the functionalities, maybe not huge improvement, but something that could help the use of the platform. For example, in September, we rolled out the version 251 that reworked the global landing page table in order to give more meaningful information, included a couple of new status for the compliance documents, some new content types, some additional metadata, and also tweak some other settings, like the ETSO applicants now will just drop a document and by default it will be the ETSO deliverable. And several others under the hood, like minor changes, but they help anyway the day-to-day work with the platform. In October, we continue and we included the main functionality linked to the quality feedback. As you know, in the framework of the LOI definition, EASA is also working in the definition of a better system to have feedbacks from the certification team back to the applicant. So everything is linked to the LOI concept. Probably most of you don't see this functionality because it's mostly from the certification side, but today the mean is really just to give you an overview and see what is behind and what we are working about. And in parallel, we are now working to improve. So what we have released in October was just the first idea, and then with the target of end of this year, beginning next year, we will improve the functionality, especially for our PCMs and experts, in order to have a better usability of the tool. So this is, I don't want to go through all the question or all the details, was just to be an idea of what is about. So the quality feedback used to be in our technical visa and expert standard of satisfaction, and were mainly few questions where you could reply low, medium, high. Now the project that has been run inside the EASA is to give far more granularity to these questions. So we will have 4 areas. We have the project planning and communication, the applicable requirement and means of compliance, the compliance data, and the on-site activities. And for each of them, there is a number between 5 and 7 questions. And so some pre-made replies that they tend to fall always in one of the 4 categories, between satisfactory, let's say partially satisfactory, partially unsatisfactory, or totally unsatisfactory. In this way, this will be filled by discipline, not only by panel. We will have a far more granular feedback from our team to be discussed and to be managed by the DOA team that then will discuss with you. Okay. And you can see not all the question will be mandatory. Some of them yes, some of them no. The one with the not applicable can be the one non-mandatory, but there will be always a minimum of information that will enable the DOA team to work. And just to close the loop, I started to say that SEPIAC is a part of Coral and is flowing into a bigger environment. So at the moment, what we can say is that on the short and medium term, the SharePoint is the technology that we use as a document management system. And probably in the future, on the medium term, you will not see anymore SharePoint as a front system, but you will see it in a better environment, in a more user-friendly interface that will help you to work. At the same time, as already said, there will be some integration of enablers needed. At the moment, SEPIAC has its own user base, and this will be migrated into a bigger identity and access management. And the same, we are working towards a definition of an enterprise service bus that some of you may know as machine-to-machine interface, in order to allow an automatic transfer and management of document between SEPIAC and the industry document management systems. So this was a light presentation that gives the status on what is what is going on with SEPIAC and where we are going in the area of the IT tools.
Thanks, Eric. Thanks, Andrea. And I think we have a few questions in Slido.
So the first one is, I think, is on me. Can SEPIAC extend to include the use by NIA when processing certification project on behalf of EASA? This is common practice, is already done by long time when we have a mixed team. The certification expert or the project manager in the NIA has access and has exactly the same rights as an EASA staff. The advantage of SEPIAC is that in the moment is hosted in the cloud, so we don't have any issue in granting access to external entities.
So yes, there is a roadmap, and I think it should be shared on the website. So we'll see to make sure that there is more information given to you on the website. So far, year one was end of 2017 till mid-2018. It was the preparation phase. I came to see some of you actually during that period. Then mid-2018 to mid-2019 was the transformation of EASA's IT systems into agile systems. So we went from waterfall to agile systems. That was the change of philosophy inside EASA. At the moment, we are busy buying the different platforms. So we're buying 4 platforms. The first one we're buying is the digital access management platform and the security platform. The second one we're just about to buy is the low-code programming platform so that we can accelerate the way we work. The third one that will be bought will be SAP PO, so therefore the machine-to-machine. And the last one we will buy is the data platform and the data lake or data puddle, depending on how big it gets. The idea is to have digitized internally by 2023 and then to propose new products from then on. But we'll put all that on the web.
How could we submit large analysis file and largest videos via SEPIAC? Well, SEPIAC doesn't have really has the same limitation as SharePoint. It's based on SharePoint 2016. So if there are no network issues, it should be able to handle quite big files. I never tried, to be frank myself, with something bigger than 200-300 megabytes. I don't know if here in the question we are talking about gigabytes of files or only a few hundred megabytes. But I never experienced myself big limitation on these aspects. The next one is on me as well. Yes, at the moment we haven't invested so much in the KPI discussion. There were some, I mean, we have introduced already with, I think was version 2.2, some average KPI, and then we haven't invested too much more on that one, considering that with all the takeover from the Coral, this is something that is more, let's say, it's more treated in a wider scale than just in this tool. And would just record a change status of a document.
Okay. Andrea, maybe for the next question, the two purple ones, will the detailed questions and ratings made available to applicant with rationale when needed? I think that's the aim of the system. There were two other questions that are gone. The plan is that we share these detailed questions with industry and the CCOM, I think, in the meeting next week. And from then it will be also shared with everybody afterwards. Will SEPIAC become mandatory for DOA? I'm not quite sure whether that has been decided yet. I don't think so. But
I think it's still in discussion. Of course, with moving to the quality feedback, we would need to have each project created in SEPIAC in order to have a consistent reporting structure. Otherwise, we will have holes. And I think here is mostly due to the fact that we need stronger infrastructure to exchange data before putting in mandatory, because especially for bigger projects, if we include it as mandatory, it would mean that someone will have to manually input a lot of documents and to manage them afterwards. So this was the reason why currently we haven't set it as a mandatory, but just as a support to the projects. For the extension to the continued airworthiness and DOA, at the moment there are not plans to tackle it in a systematical way. Of course, we have the possibility since I think it was the 2.5.1 to open generic projects with externals. So we could always create a generic project for continued airworthiness with one applicant. But at the moment, with the transition to Coral, we don't have anything in the plan to really develop something specific for DOA and continued airworthiness activities.
okay, thanks Andreas, thanks Eric for the update. That brings me nearly to the end. No other presentation, don't worry. But if you have listened carefully this morning when Rachel said 10th anniversary, we started this kind of events and sessions with this workshop in 2009. And we had these kind of workshops every year since then. And as you can see from the audience this year and last year, it grew constantly over time. And I think this growth also shows the need and the benefit and the usefulness of this kind of event. And I think doing it on an annual basis is a really good occasion. But reflecting a little bit on the last years since 2009, how did it all start? Well, first it focused mainly on DOA topics, technical topics, whether it's flight test, ISM, competences, and some of them we still discuss, but the setup of the workshop was slightly different. And don't be surprised when some people come along now with a glass of champagne, because it's an anniversary. Huh? We have regular topics like rulemaking update, for sure with a focus on part 21 and not so much on maintenance. Environmental protection was quite high on the agenda for several times. Or other things like OSD, LOI and SMS. We heard part 21 proportionality still, or last time CS STAN for standard changes. We address topics for occurrence reporting, international cooperation. You heard Frank and Charles today again. We have regularly feedback from industry, and you will see that tomorrow with the feedback from the site meetings, but also with the dedicated presentation from the CCOM members. And I think all this developed over the years to a really successful event. And we checked the attendance list from the last 10 years, since 2009. And believe it or not, we found 6 external people, beside a number of EASA colleagues, who attended throughout all years. And I would like to ask these 6 people, which I will mention in a second, to join me here on the stage. It's Matteo Benatti from Helicopters Italia. I hope you are here. Stefan Drinkelfuß from Kinetic. And you might have changed companies over the years, but you attended. Dagmar Elton from Lufthansa Technik. Patrick Legeyek from Airbus. Patrick, come on. Just Andy Lyons from AeroSynergy Limited. I hope you're all here. Patrick, Dagmar, come up to the stage. And one more, Mark Perner from Airbus Helicopter. Oh, Matteo? Yes. Okay, perfect. Oh, I agree. So we are missing 2. So Stefan Drenkefuß is not here. Okay, and Andrew Lyons? Registered, but didn't appear. Okay. No. For the other ones, we made sure that they attended. So I don't know whether you came here all the years voluntarily or whether you were asked to join.
Voluntarily.
Yes. But I think it's great to have you here and to have also the experience exchange with you over all these years. And I think it shows also the commitment from you all, from the whole DOA and industry side, to these exercises, to these events. And we have a few gadgets for you, very sexy. An EASA cap to wear, because you're part of the EASA family. You will get all of them.
Okay.
And a baggage tag from EASA also for you, for your luggage. I hope it doesn't get lost easily. So with that, when I get a glass, please raise a glass with me for a toast. You need one as well. Perfect.
Already supplied.
Thank you. So to the anniversary of this event for the last 10 years. Thank you.
Thank you. Can I say just something?
If you want to.
So I would like to take the opportunity to say that I'm joining the first workshop in 2005. Today it is my last workshop. I will retire early next year, so all the best for your future.
So I will give you the second. Yeah, unfortunately.
Thank you, Marcus. Unexpected.
It was very surprised.
Yes. That was supposed to be.
We've started in 2006.
Yeah, but this, there it was different.
Yeah, yes, right, you're right.
In the
Then we had the certification.
and the youth was
The mobile with the Paris. Then it was merged
2005.
2009.
And at that time it was just only 15 people.
The first workshop in Dassault.
In the
certification.
I was 75.
Nein,
No.
rosa haben wir leider.
Wir haben keine rosa Mütze.
Thank you so much.
Thanks. And with that, we are nearly finishing for today. We have the reception from 6 o'clock onwards outside with some drinks and some food. Ample of time to exchange views, old stories from the last 10 years, or just some technical topics. Thanks a lot, and tomorrow morning we start early at 8:30. Danke euch.